Hello and welcome to our spring tea with Curlin Walsh Law. Today I am going to talk about a couple subjects that I get asked about all the time, a couple of frequently asked questions. The first frequently asked question is, what's the difference between a will and a trust? Well, let's take each document. A will is a document whereby you determine who gets what you have and whom you put in charge. It's an important seminal estate planning document, and yes, it should be in every estate plan. But here's the big surprise about a will. A will alone does not avoid probate. A will is based on probate law. It's a list of instructions for the executor of the will and the probate court that the will is going through. It is designed for probate. Now, you may know someone who had a will only, they never had to go to court. That's probably because the big stuff was taken care of through some other means. There was beneficiaries on the account, joint tenants on the home, and maybe payable on death on the bank accounts. The will was maybe only needed for a little bit of personal property. However, if the will is the only plan in the estate and someone passes away and there is something like a home, which many of us have in our portfolio, then that will have to go through the probate process. We talked about that just a couple of weeks ago. It's expensive, it's long-winded, it's public, and can absolutely be avoided with a trust. So why are they different? The trust is based on trust law, and we've had a new trust law here in Illinois, a really good update to trust law in January of 2020. So the trust has its own law, the trust is its own world. Within the trust document, you name a trustee and a beneficiary. It's your little treasure chest for whatever you put in there. And if something should happen to the trustee, mom or dad passes away, then they were the beneficiaries, and now the children, to use an example, are the beneficiaries. So that trust exists in its own vacuum, is not dependent at all on probate law. So you really have effectively avoided the whole world of probate by getting a trust. And that's the difference. So every estate plan we do, if the trust is the basis of it, then we still have what we call a pour over will, because we have to allow for human frailty, for the possibility that something may be outside the trust at the time of death, and therefore we use that will to pour anything outside the trust in the trust so that the trust provisions will prevail. So that is the main difference between a will and a trust. Trusts also give you so many more choices on what to do with the estate, how to protect the assets, how to protect the beneficiaries. But we've talked about that in other videos and we'll talk about it again. The main difference then between the will and trust is the law that they're based upon, and the difference to you means whether or not you can avoid that costly public court process. Now, another question I get asked very, very often is, we had our estate plan done years ago. We got a will when our first child was born. Do we need to update it? Well, the answer lies with you, and you need to ask yourself, what has changed in that 20, 30 years? Has your family changed? Maybe those little children are grown now. Maybe you named your sisters or brothers or friends to go into that position, and now your children are well able to be your trustees and your executors and your powers of attorney. Have your assets changed? You may very well have done that estate plan when your children were born, you had just bought your home, you were just starting to accumulate your retirement account, you didn't yet have a brokerage. That may all have changed now as the years have passed and you may be getting ready to retire. I will tell you, What I have seen for most people are three big estate planning stages in their life. Some people plan more, some plan less, but often I see young couples planning when they first have their children because they're thinking, oh goodness, what if something happens to us? They want to make sure that those children are provided for, even if they're not there. Fast forward 20, 30 years, those children have grown, assets are accumulated, home is paid for. Maybe it's time to go into a trust based plan, and maybe it's time to get powers of attorney in place because what if we become a little less able? Fast forward another 20 years, we're now getting into those later decades. The estate plan truly is no longer about a disaster or a what if. We truly are now in a position where we need help with finance, we need help with healthcare, and maybe there's a little declining capacity, and maybe things have changed again in that 20 years. So, for a lot of people, three times of estate planning in their life is going to be enough. And as I said, depending on the complexity of the family situation, as people move, as people improve, people move in and out of your life, you may need more planning or less, but you may very well need to update your documents. And usually that's when the law changes, your family changes, your assets change, your relationships change. I do have for you an estate planning deficiency checklist, and I am going to post that for you in the comment section below, and it will go through every single document, every single question you need to ask yourself about the law, about your assets, about your family, about those you have chosen to be in positions of authority, and it'll help you make that decision as to whether or not you need to update a document you did years ago. As always, I am here to help if you have any questions, and you know how to find me. So that is our little spring tea once again for this week. I will join you again next week. Thanks for your company. Thanks for watching, and I will see you again soon. Bye.